So again, welcome everybody. My name is John Watts, and we're going to talk about arbitration. And we'll have some other webinars on arbitration, but this specifically, I want us to think about a very frustrating situation that often comes up. And this will be what's on the screen, kind of our roadmap or the facts that we will look at, our scenario, if you will. And so this will specifically be about a cable company or satellite company. And, but understand it has more application than that. I just, rather than sort of talking in general or abstract terms, I wanted to have sort of a fact pattern that we could go through. And we'll get into this in just a moment, but I want to share something with you that when I was a kid, I learned about this. I thought it was interesting. And that is, in the Middle Ages, there were these folks that were alchemists, and they wanted to do alchemy. Well, what is that? Well, that's where you take a base or a common metal, and through mystical arts or science or whatever, you transform that into gold. Well, that would be pretty cool, right? If you could, just take a bunch of scrap metal and turn that into gold. It'd be like, I guess our modern version would be, if we could turn an email into a entire Bitcoin, that would be pretty cool. Okay. Well, they weren't successful. But what we have tried to do in my law firm is sort of consumer alchemy. Take a bad situation and turn that into something good. And I'll give you sort of the classic example. And we've been doing this for many, many years. So we have somebody sued by a debt buyer. Well, that's a bad thing, right? You're sued for $5,000. Well, then if we can win that debt buyer lawsuit, and then we dispute with the credit bureaus and they don't take that account off, now we sue the debt buyer, we sue Equifax, Experian, TransUnion. And so what started off as a terrible situation, I have been sued by some company I never did business with, instead of us paying them money, now there's many, many, many multiples of that money coming back to us. So this situation that I have on the screen is similar. Okay, so again, you can sort of change the name of the company, but just imagine you have a DirectTV account and you move. And so you call them up, you say, hey guys, I'm moving and I want to cancel my service in 30 days. And they say, we're happy to do that. You got to get the equipment, the gateway, the router, whatever they want to call it. And so you say, well, how do I do that? Can I just take that to an AT&T store? They go, no. You got to take it to a UPS store, and you don't have to box it up. Just take it to them and they'll ship it back to us, no charge. You're done. So, okay, that sounds pretty easy. And so you take the box, the gateway, the router, whatever, you take that to the UPS store and you leave and everything's great. You never get a phone call, never get a letter until like 2 years later. And then a collector, a common one is a collector called Enhanced Recovery. They show up on your credit report. So on your phone, you get this ding on your phone that says, from Credit Karma, which says, hey, your score just dropped 40 points. You're like, what? I've got a house I'm closing on in a month. And you're trying to figure it out. And so you went through our previous webinar series. So, Credit Karma has its uses, but it's not your real credit report. So you go to annualcreditreport.com, you pull your real reports and like, wow, this collector is on there and it's $150. And it says it's for DirectTV. And you sort of match up the dates and you figure it out. Maybe you call the collector, you call DirectTV, and they're like, yep, you didn't return the equipment. You're like, I did return the equipment. So here's a question. What are your options? What can you do? What should you do in that situation? Well, one option is to ignore it. Okay. Another option is to, and we covered this last week in our dispute masterclass, is you send a dispute letter to the collector and you either add to it a request for information. Hey, give me information. Exactly what is this? Check your records, check with AT&T, DirectTV. Did they get the equipment? Here's the UPS store, whatever it is you're asking them to do and whatever information you're giving them. Or you could send them a refuse to pay. Basically says, don't ever call me or contact me again. Now, you could do a dispute letter to the credit bureaus and say, hey, this is not accurate. I do not owe this debt. Get it off. You could sue the collector under the FDCPA, Fair Debt Collection Practices Act, or you could sue the collector and do arbitration against DirectTV. Okay. So let's go through these kind of quickly. What if we just ignore the collector? What's the advantage? Well, it's easy, right? I don't have to do anything. I see it's on my phone. I get the collection letter and I just say, I'm not going to do anything about it. Well, that's easy. Not to spoil it, but that's a terrible idea. Okay, but it is easy. And there's a chance that they'll just magically go away. Not very likely. So here's the disadvantage. Your credit's trash. You're going to get letters. You're going to get calls. And it's really unlikely that they just like wake up one morning and say, you know what? Today's the day that we're coming off Cedric's credit report, right? They probably just don't magically think that, okay? So what about a dispute letter, okay, where we ask them for information? Well, that has some advantages. I have them on the screen. You know, if they update your credit report, they have to mark it as disputed. Maybe when they try and get this information, DirectTV says, yeah, you owe nothing, which, by the way, here's a little hint. If you call the cable company, 50-50 chance they're going to tell you, oh, you owe us nothing. Everything's good. That might be a useful strategy, particularly if the call was recorded. Just saying. Now, they may send you information that shows you owe $10, not $150. Well, that could be useful. You could end up suing the collector because it's a bogus debt they're collecting. Or there could be other violations that you find out. Now, what are some disadvantages of sending that dispute letter requesting information? Well, they'll keep it on your credit report. Now, they're supposed to mark it as disputed. If they don't, you sue them. Sometimes they go away, you know, and then, you know, it's like, oh, thankfully they went away. And then a couple of months later, boom, a new one appears. And that's this sort of whack-a-mole. If you've ever been stuck at a Chuck E. Cheese on a Saturday, you remember Chuck E. Cheese before COVID? I guess they're still around. I don't even know. But, you know, and you're like doing the whack-a-mole. Well, that's how these collectors can be. And you're still waiting. And the problem is not solved. The problem is DirectTV is holding this account and just sort of shipping it out to these collectors who are taking shots at you. Well, what if you do a refuse to pay? Well, same thing, no more communications, or you sue them. If they update your credit report, don't mark it as disputed, you sue them. And sometimes they'll go away. But again, it doesn't absolutely stop the credit reporting, and it doesn't solve the problem. Well, what if you send a dispute letter to the credit bureau? That was our 6-part webinar series on how to fix credit report errors. Well, they may delete the credit reporting. That's great. You may be able to sue, okay, the credit bureaus or sue the debt collector. And, you know, if the debt collector, this is sort of an advanced thing, but if you send the dispute letter to the bureaus, Equifax, Experian, TransUnion, and that's how they normally do, then they notify through eOscar, just the communication process, they notify the debt collector, hey, you know, this Kate or Warren or whoever, they dispute this debt. We want you to investigate it. Well, then that debt collector now knows the debt is disputed. So they have to mark that. If they don't, then you sue them for that. But what are some disadvantages? Well, again, we're not going back to the source. And I may have mentioned this in a video earlier this week. Sort of like you're playing a war game of some type, chess or whatever it is, where you got two kings there. And one king is sending an army out at you and you're fighting it. And you may be successful, but that doesn't kill the king. Eventually, you've got to go attack that king and kill the king, right? So this doesn't kill the king. This doesn't solve the problem by getting rid of the DirectTV account. And again, just because it's disputed doesn't make it go away. Collector can still call, right? Or maybe that collector goes away once you dispute it through the bureaus, and now they bring another one. So now we're back to that whack-a-mole game. So you could sue the collector under the FDCPA. I like doing that, okay? So when we sue the collector, normally they come off your credit report, they never bother you again, they pay you money, that's good. But remember, these collectors normally don't own the debt. And so all they can do is say, okay, we'll leave you alone, we'll pay you money, but then the debt goes back to DirectTV, and they just send it out to another one. So again, they're kind of like this king that's just, they're sending these troops out, no damage to them, right? They don't care if you sue the collector. And so again, it's this whack-a-mole game. So Here's a strategy that we recommend, and I'll talk a little bit more about this, sort of how we came up with this. But you sue the collector under the FDCPA. So you get all the advantages we talked about, but you also go after DirectTV with arbitration, and that kills the debt at its source. Okay, this solves the problem. Here's a disadvantage. You got to go through a lawsuit and arbitration, and this is a more complicated strategy. So, you've heard the expression, or else you watch the very old Star Trek, where it talk about, well, everybody else is playing 2-dimensional chess, and this guy's playing 3-dimensional chess. You're operating at a higher level here, and people may not understand all the moves, but then when it's done, they're like, oh, now I get it. So I'll give you a real quick background, then I'll grab some of the comments because we're about to move into another section. So I've been suing debt collectors a long time. Okay, very familiar with that. Done jury trials with debt collectors. We get that. I was doing arbitration before suing debt collectors. I started doing arbitration in 1995, and I've seen it change tremendously over the years. And what I primarily used arbitration for were really big cases. So it might be a small business suing a major company. We're asking for hundreds of thousands or millions of dollars, or even consumer cases where we're dealing with a credit card company, and these are cases that are big cases. We have arbitration cases right now. I'm trying to think the sort of, not talking about what we're doing today, but the sort of Fair Credit Reporting Act, FDCPA cases against furnishers of information, or even just if they haven't credit reported, just against debt collectors in general. The ones we have in arbitration right now are 6-figure cases. Okay, so I sort of kept those two worlds separate. It's like FDCPA and big arbitration cases. And a while back, I started thinking, well, wait a minute, we can combine these because we've got this whack-a-mole problem, right? Like I can sue these collectors over and over and over, but how do I kill the debt? And then the idea of putting these two things together, where it's not we're choosing, well, do I either sue the collector or go after DirectTV, Charter, whoever it is? So let's put these together. And so that's how I got to this point. Let me see here a few of the comments here. So there's Cedric. Hey, buddy. Good to see you here. John Black. Good to see you. Warren. And Eric asked a good question. Is there always an arbitration clause? No. There's not always, but there's almost always an arbitration clause. And hey, John, the reason is that these companies, this is the whole idea of arbitration. Okay. So if I can tell you the real story, not kind of the PR story that they tell, the real story is arbitration exists to prevent class actions. That's the story. Now, they don't want you to be in front of a jury. They don't want you to do sort of this mass joinder of cases. Okay. But the real thing is these companies go, you know what? We're ripping off 100,000 people a year. It's only worth, $100 to each person we do that to. But, $100 times 100,000, do my math there, that's a big number. Okay. Make it even bigger. We're doing this to 10 million people a year. Okay. So now the numbers get staggering. And even though a person's only just hurt a little bit, when you add everybody up, it's massive. So they said, we got to stop that. So they said, well, let's do arbitration. And let's put in there what's called a class waiver, a prohibition on doing a class action case. And so, for example, in my state, Alabama, for years, our courts were very hostile to arbitration. And we were sort of the whipping boy with the U.S. Supreme Court, where, our court would say no arbitration. We have a policy in Alabama against arbitration. They go up to the U.S. Supreme Court and they would like smack us down. And so then the big battle was over this class waiver, and that was successful. And these companies were like, yes, we finally achieved it. But the way they had to do that was to sort of bend over backwards to be fair. And so we would make these arguments like, And again, I've used arbitration, but I've also fought against arbitration. We make these arguments, hey, it's too expensive for our consumer. This is unfair. It's not what we'd have to spend in court. And so they started changing the arbitration agreement. So to go back to your question, Eric, is there always arbitration? No. And if we think about credit cards, Capital One typically does not. They used to, and we made that very expensive for them. And they took that out, not because of me, but just saying they realized this was very, very expensive. I think Citibank may have just brought them back, but for a number of years they didn't. But in the cable box world, okay, and in the cell phone world, you'll almost always find it. So it's a very long explanation. Great question there. And hey, Deandra, good to see you. Let's see, Jeff asked, so arbitration can be started by consumer without having to sue? Yes, that's right. And I'll show you, just as an example, the DirectTV arbitration agreement. So Cedric asked, do we just threaten them with arbitration or can we file ourselves? So most of these companies, and it's gotten a little bit more elaborate over the years, now they have sort of a pre-arbitration dispute or claim that you have to file. And I'll show that to you, but it can have some really cool advantages. And so Eric says, so to avoid civil liability, basically their idea behind, yeah, absolutely. And I'll tell you a funny thing. So remember what I said, it all comes down to class actions. They'll talk about, well, punitive damages. Hey, we can get punitive damages in arbitration. So take two quick stories. This was one of my very first arbitration cases, and I was working on it with, other lawyers. And it certainly wasn't my baby that I was, bringing to life here, but I did work on it right when I first became a lawyer. And that is, we had this sort of medium-sized company suing this huge computer company. I won't name them. And they forced us into arbitration. We fought it all the way to the Alabama Supreme Court. We had to arbitrate it. So it was a massive arbitration. I mean, weeks and weeks of hearings, all these depositions. And there was a provision in the contract that, look, it was plain as day. It said if we sued this big computer company, we could not recover more than $100,000 in damages. It flat out says it. So we're in arbitration, and we say to this panel of arbitrators, look, ignore it. Do the right thing. You see all the damage this has caused us, and they awarded us a 7-figure verdict. Now, you can imagine this big computer company has like a complete meltdown, or as we'd say in the South, a complete come apart, okay? Just absolutely going crazy, rushing back to the judge. Judge, this is so unfair. These arbitrators didn't follow the contract. And we argued that they had the right under the law to disregard that what's called damage limitation. But the judge is just sitting there like laughing at these people, okay? And he's like, boys, you wanted to be thrown into arbitration. You ain't getting out now. And he just like stamps the award as a final judgment. And so you can get big awards in arbitration, okay, in the right case. But here's the funny thing now that's happening. Remember, it's all about class action waiver. So some lawyers got together. I think it was the DoorDash people, that deliver the meals. And they figured out DoorDash was ripping these people off. But they had arbitration, and they had a class action waiver. And so the lawyer said, fine, instead of getting one class representative to represent everybody, we'll just gather up like 12,000 people, DoorDash drivers. That's what they did. Filed them all into arbitration. Well, as you'll see when we get into the details of the rules, that is incredibly expensive. I mean, you're talking like minimum $4,000 per case that the company has to pay before we even get to, are they right or wrong? So they go to federal judge, like, this is unfair. We never dreamed we'd get hit with all these, things that's too expensive. You know what? It's like we should let one person go and represent everybody. And the judge is laughing at them like, hey, you wrote the contract, you're stuck with it. Go pay the money, okay? So they only do arbitration, put in the clauses to hurt consumers, and they're trying to be very fair to avoid the class actions, but now it's turning back on them. So now you're seeing these same lawyers that for years were like, arbitration is the best thing in the world, and every company should have it. They're now going, wow, we didn't expect it to be used against us. we thought it would only make lawsuits go away. We weren't expecting people to actually use it in an effective way against us. So anyway, I'll get back to this here. But let's go to the questions here. Kate says, I think most class actions like getting peanuts. Yeah, that's right. And I tell you, I mean, my very first case I filed in 1995 was a class action case. So I'm no stranger to class action cases. I very rarely do them because I think for the class members, frankly, it's not very good. Okay. And so I prefer to do individual cases. Now I may gather up 100 people or 500 people, but let's get everybody their full award, not something where everybody gets peanuts, like Kate said, and the lawyers just get a big award. Let's see. Kennard says, all right, say you do a dispute, they still send a letter to take you to court. What can you do? So I think what you're talking about is when credit card companies suing you or a debt buyer suing you. And that is a different issue. If there's enough interest, I'll do a webinar just on that. With this, I'm really talking about where we're the ones taking the initial action and we're going after the debt collector and after the sort of the original creditor, the cable company here. And Eric said individual case is terrible. Yeah. So that's, that's the idea that all these companies had is like, well, nobody would do this. And look, I'm embarrassed to say for sort of my world of PI lawyer, personal injury lawyers and consumer lawyers, a lot of times when we'd file a lawsuit and they would force us to do arbitration, a lot of lawyers just give up. And we would not. We would actually go file the arbitration and the lawyers were like, what are you doing, John? Like, well, we filed arbitration. Like, well, nobody files arbitration. You're supposed to just go away. Well, we didn't go away. Let's go arbitrate it. They're like, well, my client's going to have to pay a lot of money on this. I'm like, I know. I mean, just give you an idea, not with cable companies because they use a different company, but there's a form of arbitration or an association called JAMS. And these tend to be like retired federal judges. And I mean, the guys at AAA are good, which is American Arbitration Association. But JAMS just tends to be a little bit more experienced. We'll do a 2-day hearing and they'll send a bill right out of the gate to the defendant. This is just to pay the arbitrator. It's not to pay the arbitration group, just to pay the arbitrator. It'd be like $12,000, $13,000. Now, when we file a lawsuit, we pay the filing fee, $400, $500, $600, and the defendant doesn't pay anything. So that's, again, these defendants start saying, well, we never imagined you would actually do this, or we thought you would do a document only review, which we'll get to that in a moment. All right, so let's go back to this. So real quick, this is not a deep dive on the FDCPA. We'll do that another time. But what can we sue for? And there's more than this, but just kind of look at this 1692E. This is part of the FDCPA. This says a debt collector may not use any false, deceptive, or misleading representation or means in connection with collection of a debt. Well, go back to our example. I turned the equipment in and this debt collector says I owe $150. Do I owe $150? No, I don't. So therefore, when the debt collector says, John Watts, you owe $150, that is false, that is deceptive, that is misleading, and they're collecting a debt. Now, these are just some examples. So we have 1692E, and then we have all these illustrations or examples. So part 2 is false representation of the character, amount, or legal status. Well, do I owe $150? No. Do I owe any debt? No. Okay. So they violated that. Subsection 8, communicating or threatening to communicate to any person credit information which is known or which should known to be false, including the failure to mark that is disputed. Now, if I haven't told the collector, then they may not know that, unless for every 10,000 accounts they get 1,000 people saying, hey, I turned in my cable box. And they're like, yeah, that's true. Well, then maybe they do know or should know that this is false. Subsection 10, the use of any false representation or deceptive means to collect. I'm just showing this to you to say, we can go after the debt collector just like that. We don't have to go through a bunch of dispute letters, call them a bunch of times. Now, there are some advantages to doing that, reaching out to them, but we're not required to. Okay. Well, what can we get? Statutory damages up to $1,000. That's where we don't prove any damages. You get actual damages, two types, economic. So this is sort of the classic case. It's like having a flat tire. It's never convenient. This, remember I said we start off and Credit Karma alerts us on our phone, 40-point drop. Well, we're closing on our house in 3 weeks. Pretty bad timing, okay? May jack up our interest rate, may do other things that maybe we have to give a bigger down payment. We have economic damages. Also emotional distress damages. Hey, I don't owe this debt. Why are you saying I owe? Why are you trashing my credit report? Why are you claiming I owe this money when I don't? That is so unfair. It's so upsetting to me for you to do that. And then cost of litigation. So was it the filing fee, other things, and attorney's fees. All right, so let me just show this to you, and then I want to talk to you about bona fide error. This is section 1692K. I just want to show you what the law says about damages. So any debt collector fails to comply with any provision of the subchapter with respect to any person is liable to such person for actual damage sustained. That's what we're talking about. Economic damages, emotional distress damages. And in the case of any action by an individual, such additional damages as court may allow, but not exceeding $1,000. That's the statutory damage. We call them statutory damages because they're in the statute there. And then if you're successful, the cost of the action together with reasonable attorney's fees. Okay, so let me take a step back. If we don't tell the debt collector, hey, I don't owe this money, do they have any defense? Well, they may have what's called a bona fide error defense. That's where they can say, look, we have all these elaborate procedures. We follow them, we enforce them, and they're designed to catch errors like this, and it just sort of slipped through the cracks. Well, I'll just tell you from the standpoint of a lawyer who's been suing debt collectors for, I don't know, more than 15 years. When we see a lawyer, almost always when we see a lawyer or a company say, hey, I have the bona fide error defense, my partner, law partner, and I look at each other and we go, all right, it's now amateur hour, okay? Because these guys don't know what they're doing because it's a very difficult defense to prove. And think about it in context of our fact pattern here. I returned the equipment and DirectTV sent it out to Enhanced Recovery or whoever. Well, Enhanced Recovery has got to come in to prove bona fide error and say, look, we make DirectTV swear that they never send us a bogus account. Okay. Well, how many of the 10,000 accounts a month you get do people complain about? Well, we don't want to talk about that. That's privacy concerns. Like, no. We need to know. You know, is it one person? Is that 500 people a month? And then when you go back to DirectTV, do they say, well, we'll pull the account? Well, that ought to tell you there's a problem here. So let's get into that. Let's find out how many disputes are we talking about? Well, see, now Enhanced Recovery is getting nervous because that's going to start throwing DirectTV under the bus, right? And they're saying, hey, this is DirectTV giving us bad information. Well, DirectTV's over there going, really, you're going to throw us under the bus? Give us those 547,000 accounts we've sent to you. Give them all back and you get no more. And by the way, I'm going to call my buddy. She's the general counsel of another company and sends you 20,000 accounts a month. I'll tell her how bad you are. You'll lose all those accounts as well. So is Enhanced Recovery really going to come in and say, we made DirectTV swear and we challenge them, only give us good information? And are they really going to, like, under oath, throw DirectTV under the bus? Whenever we encourage them to do that, any of these debt collectors, I say, you know, they go, John, you don't understand. We got bad data, bad information from the original creditor. It's not our fault it's theirs. I go, man, I'm so glad you told me that. Let's get your people swearing under oath, and I'll write out the affidavit for you to sign. Man, we're going to barbecue that original creditor. Well, now, John, you know, let's not get carried away, and I'm sure we can work this thing. Again, it's amateur hour when they talk about bona fide error. Let's see. Adrian says, I took Midland Credit to arbitration after it tried suing me. It's going to cost them so much to collect, only $2,200. They paid all the arbitration fees, $4,400. Yeah, so let's talk about that. I was going to cover that later, but I'm glad you brought that up. So this is a tool. This is a strategy. Remember, three-dimensional chess here. This is not a, silver bullet, genie in the bottle type of thing. And there are people out there selling courses. I will train you how to do arbitration. And first of all, what you'll get in this webinar is, if not, exceeding what you can pay for, it's 95% of it. Okay. And it's accurate. I'll just put it to you that way. But what they say is, if you just do arbitration, every debt collection lawsuit against you, every original creditor lawsuit, they just magically go away because they'll never pay the money. Well, the truth of the matter is sometimes they will. Now, Midland has, I want to say 5 years ago, AAA said, we refuse to do any more arbitrations with Midland because you won't pay our fees. Okay. And so we've been kind of watching them. And I personally don't use arbitration when we've been sued by a debt collector. If I needed to, I would. I just haven't had a reason to do that. So understand, they may, as a business decision, just like Adrian's talking about, we say, yeah, we sue for $2,200. We'll pay $4,400 because we want Adrian to go out and tell the world, yeah, they did pay the price. So let me tell you an illustration or story. So when I first started practicing law in 95, all I did was personal injury. I started adding consumer stuff about 2000. So there was a rule of thumb in a car wreck case where liability was clear. In other words, the person ran into the back of me while I'm stopped at the traffic light. Pretty much their fault. That you would take your medical bills and maybe lost wages, whatever you have, and you would settle for 3 times that amount. So I have $5,000 in medical bills. State Farm, Allstate, whoever would pay me $15,000. This was sort of the theory, not exactly, but kind of the theory. One of those $5,000 was to pay back your medical bills or to pay you for your medical bills. Another one of those $5,000 was to pay your lawyer. Another one was to pay you for pain and suffering. Well, Allstate came along to create this elaborate computer program called Colossus, and they had McKinsey Consulting working with them. And they kind of crunched the numbers, and this is just a small part of that, but they said, if it's a minor impact soft tissue, so that's called a missed case, minor impact soft tissue. So your car's not completely trashed. And when we do x-rays, we don't see, discs that have been destroyed or anything like that. It's, oh man, my neck's hurting. And if I turn a certain way, it hurts. And this has been going on for 6 months. And the doctor says, I can't see it. I understand what you're saying. Go to a chiropractor, go to a massage therapist, and give you an injection every so often. Allstate came along and said, we'll pay $1,000. And the first time I heard them, I said, you talking about $1,000 over the terminology is specials, your damages that you have. You talking about $1,000 over my medical? I'll pay you $1,000 total. It's like, that's crazy. We're not going to take that. They go, okay. This was the mindset. They would spend $20,000 on their own lawyers defending that case that they could have settled, let's say, for $10,000 or $15,000. They'll spend $20,000, $30,000, $40,000 defending it, and they might even get hit for a $10,000 verdict. You go, why would they pay $50,000 when they could have settled it for $15,000 just like that and not pay their lawyers any money? Because they wanted lawyers like me. When you come into my office and you say, hey, I got, rear end collision, and, I look at the pictures and it's like your bumper's a little messed up, but it's not like your car's destroyed. And you say, I've been going to a chiropractor, my neck hurts. And I say, well, let me see the crash report. And it says Allstate Insurance. And I go, whoa, I don't want to deal with that because that's a money losing proposition for me as a lawyer. That's why they did it. Now, there's a way to handle those cases where we turn the tables and actually make those cases worth much more. But understand, these businesses, it's a business calculation. And some accountant somewhere is figuring this out, or a consultant is, and they may decide it's better to spend a whole lot more money to send a message to everybody, hey, don't think arbitration is get out of jail when Midland Funding sues you. So again, sort of a long detour there, but hopefully that makes sense. Let's see. Kate says, did nothing with my lawsuit. Midland Credit is they will need to prove they actually own the debt. Yeah, and if you sent them to arbitration, they still have to prove that. Okay, it's just the idea that what kind of crazy company would pay, as Adrian pointed out, $4,400 when they're suing me for $2,200. Well, they do it because there's sort of this cottage industry of people saying, if you just you don't need to hire a lawyer, you don't need to go to courts, you don't need to get yourself ready. All you do is just make them do arbitration. They just magically go away. It's not true. Okay. It's not always true. So let's see, Kate, they did dismissal, trial court without prejudice. Yeah. So, all right. So let's go back to our slides here. So here's the arbitration. And what I want us to think about is, again, we'll do a separate webinar on when Midland sues us or Barclays Bank sues us. Okay, let's think about our situation. I turned in my cable box and DirectTV turned it over to a debt collector. So I'm thinking about arbitration. So what do I have to do before the arbitration? What are the rules? What organization do I go to? Is there an arbitration judge? What do I do? How do I start it? How much does it cost? What can I get? Will I do a hearing? Will I just submit documents? And how does all this work? What can I get out of it? And I have this highlight. Keep in mind, there are different versions of arbitration agreements, just like your credit card agreement changes, arbitration changes. And so you really have to know, what does your agreement say? This particular one is good with DirectTV. I picked it because so many people have DirectTV, or AT&T, which all the AT&T arbitration agreements are pretty similar. Yours may not be as good as this if you have Charter, for example, but it may be. And some unusual elements we'll look at, we see with American Express and Discover Card, this sort of pre-arbitration dispute that's really, really neat. So I want you to take a look at this. So let me switch the screen here. And we will go to, this is the AT&T. So yeah, hopefully this is popping up. So this is, and I'm going to give you a handout that'll have links to all this stuff, and I'll give you a PDF also. This is, you can see in hopefully the, well, actually, you probably can't see the URL, but it's att.com/legal/terms ... It's DirectTV. So this is the agreement with DirectTV. Okay. So I want to just run through this kind of quickly, and then we'll look at the AAA rules, because with DirectTV and most of these places require you go to AAA. So they say, look, most customer concerns can be resolved quickly. I'm not sure about quickly, because I've had AT&T, a long time, and it's anything but quick. But they say, in the unlikely event that customer service can't resolve, then we agree to resolve those disputes through binding arbitration or small claims court. Okay. And then they just sort of explain to you what arbitration is. They say it's more informal, a neutral arbitrator instead of a judge or a jury. It's more limited discovery. That's not necessarily true. Discovery is where you can ask questions, take depositions, ask for documents. It often is more limited, mainly because people just assume that they can't get it. Subject to very limited review by courts. That's right. Basically, whatever that arbitrator says, you're done. If you watch the NBA, or NFL or college football, and sometimes there'll be a replay, well, let's look at that on the replay. Or maybe that sporting organization saying, we want to introduce a replay. Well, with arbitration, there is no replay. There is no, let's review the call on the field. It's that arbitrator. If you win, great. If you lose, not so good. And then they say, look at this in bold here. Any arbitration will take place on an individual basis. Class actions and class arbitrations, class actions are not permitted. Okay. And then they say, for any non-frivolous claim that does not exceed $75,000, DirectTV will pay all the cost of arbitration. And in arbitration, you are entitled to recover attorney's fees at least to the same extent you would be in court. That's sort of an interesting little twist they have on it. And then look at this, and we'll look at this in more detail, but just sort of focus in on this, and hopefully this is big enough so you can read it here. In addition, under certain circumstances, DirectTV will pay you more than the amount of the arbitrator's award. Well, that sounds pretty good. And will pay your attorney, if any, twice his or her reasonable attorney's fees if the arbitrator awards you an amount greater than what DirectTV has offered you to settle the dispute. Now, that ought to get your attention, okay? So think about our scenario here. DirectTV, $150 charge. They send it out to Enhanced Recovery or whoever. And now I'm going to arbitration. So we've talked about suing the collector. Well, I'll just tell you, we don't sue collectors unless they're paying thousands and thousands and thousands of dollars, okay? But put that aside. Now we're focused on arbitration against DirectTV. Hey, you sent out an account that I don't owe, and that's terrible customer service. You violated the contract, whatever we want to argue in it. And there's a chance that I can get more than the arbitrator awards me, and my attorney can get paid double. All right, that ought to get our attention. So let's look at what is the arbitration agreement. So again, they have things bolded here, all disputes and claims, and it's being interpreted broadly. And look at this. So arising out of, relating to any aspect of relationship between us, whether based in contract, tort, statute, fraud, misrepresentation, any other legal theory. Pretty broad, right? Claims that arose before this or any prior agreement. Okay, it could even be advertising claims. Claims that are currently subject to purported class action litigation in which you are not a member of a certified class. Claims that may arise after the termination of this agreement. So you terminate your agreement with DirectTV, you have no business relationship with them, and 6 weeks later, 6 months later, they do a soft credit pull, an account review. What are you doing, guys? There's no account to review. All right. In that scenario, assume you owe them nothing. They admit you owe them nothing. This will be covered by arbitration, okay? Now, I think I said this in a video earlier this week. They think of arbitration as a sword they hold over our head. I mean, we sue companies, and they'll be like, now, John, you better be very reasonable because we're going to force you to do arbitration. I'm like, oh, my goodness, that would be terrible to do arbitration. And then I'm like, it's JAMS arbitration, and you're going to drop like 30 grand on that. You understand that? Oh, well, you can't arbitrate this, John. Again, remember you wrote it so broadly, and your firm was so proud of how broadly you wrote that arbitration agreement so that it would cover everything. Guess what? It covers this. All right. So the point is they want it to cover everything. All right. Now, this is getting a little bit into the details, but what does DirectTV and us mean? It's subsidiaries, affiliates, agents, employees, predecessors, successors, assigns. Okay. It's interesting. Sometimes that can cover a debt collector. Usually it's when it's been sold. Okay. So sometimes we can use this even against the debt collector. Usually though, I keep these separate. I go after the debt collector, and then we go after DirectTV separately in arbitration. All right, so we won't read the whole thing, but notice what's bolded here. You agree that you are waiving the right to a trial by jury or to participate in a class action. And now here's the part that I want to really spend some time on. Any party, so that would be us, who intends to seek arbitration must first send to the other by certified mail. Let me stop you right there. This is not the time to get cheap. Okay, so well, can we send it priority mail? It says certified mail. Just follow it. But I want to save $7. It ain't worth saving $7. Okay. Well, can I fax it to them? No, do it by certified mail. Now, understand this. Arbitration, you have the rules of arbitration, but then each company has their contract with you. These contracts are inconsistent. I mean, if we clicked on, for example, this link right here, it would take us somewhere that would tell us different information than here. Just understand they're not very organized, okay? But my point is, it says do it by certified mail, a written notice of dispute addressed to DirectTV, Consumer Arbitration Demand, P.O. Box. don't say, well, can I just drop it off in person at an AT&T? No, do exactly what we want the benefit of this. We don't want to give them any excuse to say, well, this doesn't really apply. So you describe the nature and basis of the claim, the relief sought. If DirectTV and you do not reach an agreement to resolve the claim within 30 days, you may commence an arbitration, and you can't disclose what the settlement offer was. Okay, so just hold that thought. After you commence arbitration, we'll promptly reimburse you the payment of the filing fee, which is usually $200 with AAA, but it could be different. They're saying whatever you paid, we'll reimburse you. Why are they doing this? They're trying to bend over backwards because they don't want a class action. They don't want, 10,000 people suing them in one lawsuit for, ripping them off. I really think some of these companies, it's almost like they go, you know what? Every other person that cancels, just send them to collection and claim they didn't return the equipment. I mean, I've had this, and I'm like, hey, you jokers know I returned the equipment. Oh, yeah, I see that was logged in 4 months ago. Okay, sorry about that. It's like, yeah, this is a scam, okay? So they'll reimburse you the filing fee. And look, if you're not able to pay it, they'll even pay it for you, okay? And then they say, look, we're going to be governed by the consumer rules of AAA. All right, and so then they talk about unless you agree otherwise, it'll take place in the county of your billing address. If your claim is for $10,000 or less, you can do this solely through documents, and or you can do a telephone or an in-person. Let me just give you a little bit of hint. I mean, I don't want to prejudge whether doing just documents or what sometimes is called a desk arbitration is a good idea. But let me just say that it's a terrible idea. Never, ever agree to a desk arbitration or a document-only arbitration. I guess, if I woke up in the morning and said, I'm really the most repulsive human being. I'm a jerk. Nobody likes me. I have uncontrollable anger issues. Anybody who spends more than 5 seconds around me, even puppies and kittens, hate me. Well, yeah, I guess I would do a document-only review, okay? But putting aside the 3 people in the world that describes, and I know, unfortunately, we're on the road and there's 3 of them. They're all 3 gathered together on my road, driving. But putting that aside, you don't want a document review. You want the real thing, in person. It could be virtual. I don't like telephone, but I like virtual where, we're doing it by Zoom. So anyway, let's see here. What I want you to focus on next is this right here. And look, not everybody has this. And this is the most generous one I've seen. Okay. But this is pretty good. Pretty good. If after finding in your favor in any respect on the merits of your claim, the arbitrator issues you an award that is greater than the value of DirectTV's last written settlement offer made before an arbitrator was selected. So let me tell you this. You file the claim with AAA. Pretty soon after that, you get the arbitrator, okay? So you file the claim. Normally, there's some response from the company, and then you get the arbitrator. In jams, we kind of pick by, they'll give us sort of a panel and we go, not that person. The other side says, not that person. And we get down to one person. AAA, they just give you the person, basically. You're kind of stuck with them. But look, if DirectTV gives you a settlement offer, they say, you know what, we'll offer you $250, and you reject that. And then and that was the last settlement offer they made before that arbitrator was selected. And then you go through the arbitration and the arbitrator awards you $500. Well, guess what? If after finding in your favor, the arbitrator issues you an award, $500, that is greater than the value of the last written settlement offer, $250. Yeah, $500 is worth more than $250. Then DirectTV will, look at this, pay you the amount of the award, $500 or $10,000. That's the alternative payment. Whichever is greater, well, that's pretty cool. And not or, sometimes they say or, but this says and, pay your attorney if any. Now, obviously, if you don't have an attorney, then this is of no benefit. You pay your attorney, if any, twice the amount of the attorney's fees and reimburse any expenses, including expert witness fees and costs your attorney reasonably accrues for investigating, preparing, and pursuing your claim in arbitration. So let that sink in. They make you a $250 offer. The arbitrator, we're going to see, it costs DirectTV about $4,400. Let's just call it $4,000 to get through arbitration. Not paying their lawyers, just what they have to pay at AAA. And that arbitrator awards you $500. You walk out of there with $10,000. And your attorney, which I think is a nice touch, your attorney gets paid double their fees. Okay. Now, think through for a moment. What's the implication of all that? If you know this, and if DirectTV knows that you know this, because it's obvious from the way that you're handling the case, what does that do for them in settlement? Are they feeling really confident to throw $250 out there when they trash your credit report by using a debt collector? I don't know. They might think, if they're smart, well, if we think the arbitrator is going to find in your favor, that's a lot of money. And we got to pay our lawyers, and we got to pay your lawyers, and we have to pay your lawyers again. Okay. So now look at this. Because my scenario was, what if they make you a written offer? How about if DirectTV did not make a written offer to settle the dispute before an arbitrator was selected? You and your attorney would be entitled to receive the alternative payment. That's the amount of the award, or $10,000, whichever's the most. And the attorney premium, which is like witness fees, cost, and double attorney's fees, if the arbitrator awards you any relief on the merits. Any relief. It's pretty amazing. Now you got to do things in a timely way and all that sort of stuff. And they say, look, if you end up, you could get more attorney's fees, more than double under the law, then that's great. Normally you don't, though. Okay. And they say, although some law, let me highlight this. Although under some laws, DirectTV may have a right to an award of attorney's fees. If it wins, it agrees it won't seek those. Again, why are they doing that? Because they know they're crooked and they don't want to get hit in class actions. And so they're doing this because they're trying to make it so compelling for a judge. They look how fair we are. You can get individual relief. See, the argument's always been from my side. Well, look, the case is only worth $100. How are they going to hire a lawyer to go do an arbitration for $100 if we got to spend $500 on the arbitration fee and there's no attorney's fees that can be awarded? See, this is, they go, well, here's how you do it. So you don't need a class action. I agree. Like, who thinks a class action is a good idea when you can get this? This is fantastic. We don't need class actions if we can get this. The whole idea of a class action is people have really small damage and it's just not practical to go bring a claim. This just made it practical. Okay. And so look at this. They not only bold it, but they capitalize it. Just so you understand, you and DirectTV agree each may bring claims against each other only in your or its individual capacity and not as a plaintiff or class member in any purported class or representative proceeding. Okay. And then they say they can't consolidate more than one claim. Again, this comes back to bite them when there's 12,000 of these filed. And they're like, but we want to put them together and only pay the arbitrator one time. It's like, no, you'll pay 12,000 arbitrator fees. Okay. So then they say we can make changes, blah, blah, blah. So that's what I wanted you to see there. Next, we'll turn to the AAA rules, but let me see if we have any questions. Yeah, does CFPB also have these terms on file? No, they don't on what we're talking about, but let me show you what they do have. For credit card agreements, they do. So hopefully this... Not sure why that's not sharing my screen. Let me hang on one second. Let me get my screen to share. Oh, I know what I did wrong. Okay. So you should be seeing, so it's just a Google search, CFPB credit card agreements. And so it should come up pretty quickly for you in the search results. And so it's credit card agreement database. And I mean, it's just massive, you know? And so like, let me just show you, it's Discover Bank. So we will look at this and make sure it's popping up on my screen. Okay, so here's this is the credit card agreement. So if I remember right, yeah, okay, so here's arbitration. And again, we can do a separate webinar on credit cards and how all this works with debt collectors and credit reporting. But here's an agreement to arbitrate. And you can see this part right here. Must be on an individual basis. We're not going to consolidate claims. So that is, they're obsessed with that. Okay. So they say you can go to small claims court. This is AAA. So I guess it was American Express I was thinking about that was also has jams. But so this AAA, which we're going to look at the rules in just a moment. And they say, but look, if you have a claim before initiating the arbitration proceedings, you give us written notice at least 30 days. And here's how you do it. And give us some details, supporting facts. And if you submit that claim and the arbitrator gives you more than the last written offer made before the arbitrator was selected, does that sound familiar with DirectTV? Then you'll be entitled to an award of $7,500 or your actual award, whichever is greater, okay? And then if you're entitled to $7,500, you'll receive in addition any arbitration fees or attorney's fees awarded by the arbitrator, okay? So again, it's not quite as dramatic as the DirectTV, but this is why it's really important if you're looking at arbitration that you go into the details or you get with a lawyer that understands this to really dig into the details, say, well, what's the arbitration agreement that's in effect now? Is my credit card in effect now, or was this like 5 years ago? And so the neat thing about this agreement is, let me go back, is they do have some sort of historical, hopefully that's showing up. You can say, well, I want to look at Q3 2016 agreements. And, this is searchable also. So, if you, Navy, Federal Credit Union, actually theirs doesn't have an arbitration agreement if I remember right. We've got, BMW of America, Credit Union of America. So anyway, really cool thing. Let me just drop this into the, let me share this link with you guys. CFPB credit card database. Okay, so this should pop up for you, hopefully. I wrote share now. That's just what they had. I should have said like click here or something. But anyway, and I'll drop this in the link or the chat also. Maybe easier that way. So, all right, so there's that. Let me go back to chat and then we will look at some other stuff here. So Jeff says, so what you just read, class action waiver, seems they're really incentivizing consumers to arbitrate rather than to sue. Yeah, in a sense, unintentionally incentivizing us to arbitrate rather than sue individually. They definitely want us to arbitrate rather than do a class action. But it's so what they used to have. Let me just back up a minute. So we started seeing arbitration agreements in the 90s. So there were some really big hits against companies in Alabama. And so I think Time Magazine had like a feature article or maybe a cover story that described Alabama as tort hell, okay? And because somebody would get ripped off by, let's say, an insurance company. Let me clear something out here. And so it'd be an insurance company, and the agent would lie to you, and it'd be $100 a year. These are small, like burial policies. And so they get sued, and it'd be like a $50 million punitive damage award. Those always got cut, okay? But that made the headlines. And so they started saying, well, it's these out of control juries, okay? And so they said, let's do arbitration. And so what they would do in the arbitration is they would say, it's $20,000 to arbitrate, and you, the consumer, have to pay half of that. Well, that's easy, right? We go to court. We're like, Judge, you can't make us arbitrate. It's so unconscionable, so unfair. And so they started, bringing those down. And eventually, like AAA introduced their consumer rules, which we will look at. JAMS has the same thing. JAMS is the other arbitration association. And there was a really crooked arbitration association called NAF that was just absolutely a scam. And like MBNA used them, and they just go there like they were basically controlled by the credit card companies, and you would lose arbitration. They go into court and force the award, and it was just the most crooked thing. It got shut down. Just absolute horrible. So because of stuff like that, courts were really pushing back on arbitration. Like, nah, this is not fair. This is crooked. And so these companies started changing the agreements to say, well, let's bring the cost down for the consumer. And again, you can't make a consumer pay $1,000 arbitration fee when they're suing for $100. That's unfair. And so that's when we started getting these rules. And then they go, wait a minute, now the danger is not the big punitive damage award. The big danger is class actions. And so that's where we are today. So let's see, Wayne. Well, that's a very nice comment, Wayne. Thank you for saying that. Cedric said, would you recommend consumer-initiated arbitration or counsel? So, and look, I realize this sounds self-serving. I would get with a lawyer, okay? I have people that come to me all the time in Alabama, and they're sued in small claims. And I fully explain to them how they can do this on their own. I mean, we have, videos to share with them. We have written materials. I'll even sort of do a role play with them right before their trial. I'll be the collection lawyer. Here's what you're going to be asked. Okay. You can definitely do that on your own if you're willing to spend the time. But if you're suing somebody, doing arbitration and not having a lawyer, this is what it would be like. And it was a great question, Cedric. So don't take this the wrong way. But Cedric, if I came up to you and said, hey, Cedric, I'm the head coach of, I forget, Cedric, where you are, maybe Kansas City, maybe that's the team you pull for, St. Louis. So, I'm the coach for the pro team there, and the Chiefs. So, you'll, as Kate says, go Chiefs. And I was living in Tampa Bay during the last Super Bowl, and or when Tom Brady joined the Buccaneers, I should say. So I know it's probably a sensitive subject, but so imagine this. I say I'm the new coach of the Chiefs, and I know I got this quarterback. He's pretty good, but could we go through a whole game, a whole season, and not throw the football? We just want to run the football. Now, you would answer and say, yeah, you can, John. I mean, we could just have our very highly paid, incredibly gifted quarterback just hand the ball off. That's legal. Under the rules of the NFL, but that's really, really stupid. I go, well, I think we've got this great running back, and I just don't want to deal with throwing the football. It's like, yeah, but you're taking away half of your weapons here. It's the same way. If you sue a debt collector under the FDCPA, you don't have a lawyer. And again, I know there are people out there, I run into them at conferences where like, I know better than any lawyer and I can do this better than any lawyer. And I'm like, yeah, you've done a few of these and, you got lucky. Or, yeah, the joke in the personal injury world is somebody says, hey, that lawyer, man, he's $1 million a case lawyer. Well, the punchline is, Yeah, he has $2 million cases. He's just really bad. Okay. Whereas Warren Buffett would say, a rising tide lifts everybody, but when the market comes down, then you see who was swimming naked. Okay. So sometimes people can have what appears to be success. And it's like, I'll have lawyers come to me and say, hey, John, here's this case. We settled one just like it a month ago for $3,500. How much would you sell it for? I'm like, 50,000. Like, what? We thought 3,500 was good. I'm like, I'm just telling you, it's not good. Like, we can get you more. So the point is, you're purposely, sort of tying a hand behind your back if you don't go in with a lawyer. Okay. Obviously, you got to have the right lawyer. Somebody's got to know what they're doing. And that lawyer needs to explain to you about the cost and about, there's no out-of-pocket cost to you, but what's it going to cost you to have this lawyer? And, how will a settlement work out? And look, don't get the wrong idea that, hey, every time there's a DirectTV, you're going to get like 10 grand. Okay. DirectTV, they're smart enough to know, hey, if we, send something out to a collector who trashed your credit report and you really return the equipment, we're going to have to pay some money on that. We're not going to be offering you $500 for that. Okay. And if they are stupid, then yeah, take the 10 grand. But I would definitely get with the lawyer to understand, does it make sense for you to have a lawyer? And again, think about that agreement, how they have it, where they're saying, even if you're not entitled to attorney's fees, because think about this, we can't sue DirectTV under the FDCPA. There is no what's called fee shifting. Okay, DirectTV normally doesn't credit report. They go through sort of proxies, right? They go through debt collectors. So we can't sue them under Fair Credit Reporting Act. So where do we get our attorney's fees? Well, we can do a UDAP statute, deceptive, unfair practices statute. But we also can just take that agreement and say, hey, buddy, you messed up and you got to pay attorney's fees. So again, at the risk of it sounding self-serving, I know it sounds self-serving, but I'm telling you, it's also true. It's like if you're a quarterback coach and I go to you and say, should I not ever have our quarterback throw the ball? He's like, no, I really think you ought to throw the ball. It's pretty much how Super Bowls are won. It might be self-serving and it's true. Let's see here. So Wayne asked about lawyers in Chicago. Not off the top of my head, but I will say this. In a lot of this, if it's sort of like a lawsuit, if you say to me, Wayne, I'm assuming you're in Chicago, and I spent 2 long years freezing to death in Portage, Indiana, which is near Gary, Indiana, which is, right off Lake Michigan. And it literally about killed me. I had a scholarship to go to Indiana University Law School. And I went to Alabama, a law school in Alabama, because I couldn't handle the cold. I grew up in Los Angeles and moved to Northwest Indiana, and it nearly killed me. It's just way too cold for me. So you are, people that live up there, I'm like, man, y'all are tough going through those winters. But I'll say this, if you, a lot of times you could say, hey, John, I've got this claim, and we could bring it in Alabama in court. And usually we can do the same thing with arbitration. So sometimes, we can, if it's arbitration, we can deal with that, sort of filing that, even though there's not really like a court you file it in with AAA, but we go with AAA and we say, hey, we want the Atlanta office. That's the kind of the regional office. So let me go back to this. I know what I want to share with you is the, let me see. I want to show you the AAA rules. So this is adr.org.rules, and the rest of this stuff will be in a handout I'll give you. But there's all sorts of stuff. There's labor arbitration, international dispute, blah, blah, blah. This is what we want, consumer arbitration rules. So this is the PDF of it. And yeah, that's showing up. So this is your rule book, okay? It's not the federal rules of civil procedure, the federal rules of evidence, what does, St. Louis say about the filing fee is to file a small claims. That none of that matters. This is what matters. We're not in court if we're going AAA. And so what I want you to see, I'll show you a couple of quick things here. So first, they want to make sure that this is a consumer agreement, okay? And it's a standardized systematic application of arbitration clauses. They're non-negotiable. So credit card agreements, telecommunications, okay? That's what we're talking about here, cell phone, ISP, cable TV. And by the way, everything I'm talking about applies to Sprint, Verizon, AT&T. They say, hey, turn in your phone and cancel your contract. Great, we're done. And then $600 later, a year later, there's $600 charge on it. You're like, no, you guys told me I was good. Take them to arbitration. There's a lot of leases, a lot of automobile finance agreements, pest control. They definitely like Terminex, gym memberships. Yeah, they have here health and fitness clubs. I mean, all these things will be consumer arbitration. And what that means, let me just tell you the bottom line. The credit card agreements are real bad because they'll say, we're going to split the cost of it. We don't care what AAA says, we're splitting the cost. It's not how it works. Okay. AAA says, that's cute. Let me tell you what you're doing. The consumer will pay like $200 and you guys pay all the rest. And if the business doesn't agree to it, AAA won't do the arbitration. Now, we're using arbitration sort of offensively here, right? Remember I said they hold the sword of arbitration, or we grab it out of their hand, then we like stab them through the chest. Well, they can always say, well, we're not going to pay the arbitration cost. But the downside for them is they're breaching their own contract, okay? And that will come back and bite them later when they get sued for a class action. They go, oh, now we want to do arbitration. And we can show time after time after time they've refused to pay the arbitration costs. A lot of judges say, nope, you've given up on arbitration. That's what was happening with Midland. And so I think it was Adrian said Midland went in and paid the arbitration. That's actually the first I've heard of Midland doing that in quite a while. So I think they were getting that sort of blowback on this where it's like, oh, this is a real problem. So anyway, let's go down to, I think it's about page 37 or so. And again, if you guys are interested, we'll do sort of a deep dive into literally the rules, like, okay, what's the step-by-step procedure? But I want you to see the money part because that's the interesting thing here. Let me see. I know it's exciting to watch me scroll through this. Okay, here we go. So we have desk only. Here's a little hint. Don't even read this. Like, I don't want you, I mean, obviously do whatever you want. I don't want you thinking about desk only. This is what we do. In person or virtual. So if we're the party filing the arbitration, then if it's a single consumer case, that's $200. Don't worry about multiple consumer. That's like if I gathered up 100 of these and filed them all individually, but I filed them at the same time, AAA would say, well, we'll give you a little bit of a discount, DirectTV, because John filed a whole bunch of these. It's one lawyer doing it. But look, you pay $200, but remember, DirectTV said, we'll pay you back for that. All right, now, look at what the business has to pay, okay? So there's always a case management fee. And most of these arbitrations are going to be just one arbitrator. So it's $1,400. There's a hearing fee, $500. So let's keep track of this. That's $1,900. The arbitrator compensation, $2,500 per day of hearing. Now, what does that mean? Well, they tell us that means you get one preliminary conference, 1 day of in-person or virtual, and one final award. That's what $2,500 gets you. Now, what if there's a bunch of fighting going on? We're saying we want depositions and this and that, and we're having to go back, kind of like we do with judges. Well, they're going to build a business, not the consumer. They build a business for that. What if the business says, you know what, we want to file a summary judgment type proceeding here. We don't even want to get to a hearing. Well, generally it's not allowed, but if it was, they would have to pay for that. Okay. And so, again, this line, the business be responsible for additional arbitrator compensation. So again, think about that. We're getting up, $4,000 to go through one day of hearing. So this becomes very expensive for the company. Now, we can't, and I've got a screen talking about this. We can't file bogus claims or lie about this. We're the good guys, not the bad guys. Okay. And if we do that, it'll sort of be like, there are very honorable CROs, credit repair organizations. We have some of them on this call, but there are some crooked ones who will say to you, you know what? I can get rid of all your negative stuff. I'll file an identity theft act. We'll just say it's identity theft. It'll wipe it all out. Does that work? Kind of. It's also a crime. Okay. And what it does is it ruins the thing for the legitimate victims of identity theft. Well, again, we need to use arbitration in a good way and not lie, or else we'll ruin it for everybody else. Okay. But I just want you to see this about the money and think through the implication. Remember, we're playing three-dimensional chess, right? We're going, okay, we got a debt collector. What am I doing there? We've got DirectTV. Do I want to do a pre-dispute notice? And I think that's really all I wanted to show you there. So let me, I've got another slide or two, but it's not important. Let me just talk to you. This really is, I keep using that expression, three-dimensional chess, because there's a whole bunch of factors. So, do I do a dispute to the credit bureaus? Okay. So do I call my buddy Cedric and say, hey, Cedric, I want you to do this dispute to the credit bureaus. I want you to find the errors under the Fair Credit Reporting Act. Let me see what happens with that. What comes back? Maybe it gets verified and I had a legitimate dispute. Maybe I've got the UPS receipt, right? Like, this is the UPS receipt. I took a picture of the gateway unit, the router, and I can like match it all up, and I send that to Equifax, Experian, TransUnion, and they go to DirectTV or to Enhanced Recovery, whoever's reporting it, and they verify it. I'm like, great. Now, I may or may not sue the credit bureaus. It depends on how strong my proof is, but I'm definitely going to sue whoever's reporting it, okay, under the Fair Credit Reporting Act. Well, what do I do with that collector? Do I write them letters? Maybe I do, maybe I don't. Do I do the lawsuit against the collector and the pre-dispute or the pre-arbitration notice at the same time? Or do I sue the collector and then in the settlement agreement make sure it doesn't release any claims against AT&T, DirectTV? Now, they want it to, but you can always say, I refuse to do that. Or maybe I do the dispute or the pre-notice claim to DirectTV, and then I go through arbitration with them, and then after it's done, then I sue the collector. Now, if I settle with AT&T, they're going to want to give their collectors protection. But again, I don't have to agree to it. So my point is, there's a lot of variables, and I wish I could say this is always the right way to do it, just like this. Always do it that way. It's not quite that easy, because we have to know, maybe I don't have the receipt from the UPS store, okay? But I just know, like, I've moved 12 times. I always return my equipment. I've never been late on anything in my life. I always return stuff. I've never had a library book fine. You know what I mean? Like, and I can say with confidence, I have always returned the equipment. Well, okay, that might be enough. Now, that's not enough to sue the credit bureaus for, okay? But if somebody came to me with that and I felt like they were telling me the truth with that, first of all, I'm impressed that you've never been late on anything in your life. But we might just sue for that, okay? So my point is there are different levels of proof and different damage that has happened. Okay. And so there has to be some thinking, some strategy going on with this. Let me share this one thing with you. This is really just a couple of simple handouts here that I want to share with you. And if you happen to be on your phone and you can't get to this, just email me back and I'll send them to you. So there should be these two things. One's a handout that's just got some links that we covered, a few little reminders. I do want to, let me pull up this handout here, because I do want to show you one thing where really we need to go into a little more detail on this. So, well, that's not exactly what I wanted. Here we go. Yeah, so just so you can read that provision for yourself, that arbitration provision, here's the AAA rules, sort of the big section, then you drill down into the rules. So, we've talked about this. Read the agreement very carefully. Three-dimensional chess, we're the good guys. So pre-notice dispute. So I give you an example here. And this is really just to get you started. I'm not saying like just rely on this, but you identify yourself, identify what address you had. Make it easy for them to find you. If you know the account number, say, I think the account number may be, but what I do know is I had you guys from 2015 to 2019 at such and such address. And here's what happened. And here's what I want you to do. I want you to pull the account from the collector. I want you to kill this debt. And you can give them a dollar amount. Again, read the agreement. It may say, we want you to give us a specific relief. That's just the idea. What do you want? Okay. The specific relief. And so you give them a dollar amount. Okay. And you want to be careful. Don't make it so high that it discourages them from giving you the right amount, but don't make it so low that they go, yes. You want to really stretch them a little bit and get full compensation. So again, this is just to get you started. I'm happy to do another webinar, and I'm going to talk to you guys about webinars in just a moment. Another webinar where we sort of go into, okay, well, literally what should we say, if it's AT&T or if it's this or that. But I started to do that in this, but I thought this is going to be too long if we go that approach. Not even sure what time it is. Yeah, so actually I've got to hop off here in like 8 minutes. But so just to get you started, just to kind of think through, okay, so there's nothing magical about it. Matter of fact, let me show you this. If let's see if I can get this to pop up. So check this out. When we get to the arbitration, and this is pretty common, okay? So remember, this is the part talking about you have to send that notice of dispute, and they say you can download or copy a form notice. And so they give you this link. So let's go to this link here. And it's like, hey, something happened there. And see, this part of my issue with, they're not super organized. Like now this is jumping to a wireless thing here, okay? But now they're saying you can do this online, but that's not what our agreement said. But the reason I bring this up is they give you this little PDF that you can fill out. So the billing address, do you have a legal representative? Who is that person? Then they fill this part out. So in other words, we do this for our clients. If we use this form, is it residential? Is it business? And then, what happened? Are you seeking monetary compensation? What's the amount? How you calculate it? You don't have to explain a lot to them. It's, I'll always remember we tried a case against Allstate. They were ripping off a former agent, and we sued them. And right before trial, the lawyer said, Judge, John won't tell us how much he's going to ask for in emotional distress damages. And like, that's right, I'm not going to tell you. And they're like, you have to tell us. And the judge looked at me, and he had been ruling against me like every part of it. He hated my case. And he's sort of this funny older guy, though. And I said, Judge, I'm going to decide that once I see how the case goes, And I remember he said that maybe this is not politically correct anymore to say, I don't know, but this is what he said. He sort of leaned back in his chair and he's like, boys, that's a testosterone decision the morning of closing argument. It's like, that's right. You see how the case goes. How much am I going to ask for in punitive? How much in emotional stress damages? I'm going to figure that out as we go through the trial. If you're yelling at my client during the trial, guess what? His damages are going up. So you don't necessarily have to explain how you got it. You can just say, I think that this is what I'm entitled to. Is there other monetary compensation? Have you tried to resolve it? You don't have to use this form. I just share this with you to say that, this is an option to use. But my warning is, go back to what this thing says here. It has to be certified mail. So I would follow that. I wouldn't say, well, I'm going to submit this online or something. So anyway, that's the last thing there. So let me go back and see. We've got a few minutes left here. Eric, loving all this information, make it easy to digest. Thank you, Eric. The reason is I have to figure it out myself. So I have to really break it down. And plus, I think, the way we know that we actually know something is, can we explain it in a simple way? It's kind of like any fool can make something complicated. Okay. So hopefully we do a good job of that. Wayne says, used to be against arbitration. Not anymore. I insist on doing it now. Yeah. I mean, if we had this conversation, even 25 years ago when we got that big award, I still hated arbitration. I wanted a jury. And, but I have, I've adapted. And I remember, this was 2006. I won't name the credit card company, but we sued a credit card company for an FCRA violation. They refused to fix errors. And they filed a motion to compel arbitration. And look, there was no good stuff about arbitration then. And we said, we're going to fight you unless you agree to use JAMS arbitration, and you guys pay for all the arbitration costs. We said, okay. And so we submitted the JAMS arbitration, and in the form it said, how much are you claiming? And we said, $250,000. Well, at that, they don't anymore. But at that time, JAMS had a chart that said the amount claimed, and then that showed how much the arbitration fee was. It was like $37,000. Well, normally, we'd have to pay $18,500 of that. Guess what? They sent that whole bill to the credit card company, to a lawyer. I get this call on my phone. He's like, John, what in the world is this? We just got a bill for $37,000. I'm like, yeah, ain't arbitration great? The case settled right after that. So even after that, I still hated arbitration, but I was kind of thinking about it, and we kind of played around with doing some sort of mass arbitration. And, but yeah, look, they have taken things away from us. They've taken away class actions. They've taken away some jury trials. So let's, we can complain about it, or we can go, you know what? The battleground has changed. Let's adapt. And let's make them regret ever doing that. So, Wayne, I'm with you. It's there are times where we're like, no, you don't have to compel arbitration. We're going straight to arbitration. Kate says, thanks for this great information. You're welcome. And thanks for being here, Kate. Let's see. Discover Bank requests summary judgment. They didn't serve papers. That's really going to be dependent on your state law. And, I guess I would say, if you're talking about they didn't serve you the summary judgment motion, the judge's not going to dismiss it for that. He may just move the summary judgment back. But, that really, I'll say this, if you're dealing with an original creditor and you're dealing with motions for summary judgment, if there's any way possible, you need to have a lawyer in your state help you with that. I'm not saying it's impossible to do on your own, but if you represent yourself, most judges will literally say this, like, I expect you to know everything a lawyer knows. If you're going to represent yourself, that's how you have to do it. Let's see. So yeah, you guys are very welcome. You will get a replay link. Let me tell you this, and then I have to hop off. So, this is all sort of a work in progress of doing these webinars. And so I've been doing them separate webinars, like, you log in or register for this one and this one and this one. And it occurs to me that I should probably just have a set one. It's Thursday at 11, and, the topic will change, but that way you guys don't have to re-register for them. And so it might be, well, hey, this week we're doing, the FDCPA, and you may say, I don't have any interest in that. We'll just skip it. And then the next week may be something about credit reports. You go, ooh, I want that. And then it's about arbitration or about, the do not call list and getting, the TCPA calls to your phone. So I'm thinking about doing it that way. And so I've got to figure out exactly how that works with the software. I mean, I know how to set up like a recurring one, but I need to be able to like change the title, I think, or maybe, you may just have to accommodate me. It may be like, open office hours, consumer law or something, but I should be able to change the automated emails that go out to say, hey, here's what we're talking about this week. So anyway, definitely let me know if you guys have any thoughts about that, if that would be helpful, or if you prefer to sort of get something, specific about, hey, here's the sign up sheet for, whatever it might be. So just let me know. And hey guys, I got to run. Thanks so much. I'm amazed that so many people joined me on a Friday for like an hour and a half. And you guys just let me know if I can ever help you with anything, or if you have topics for webinars. I've got sort of a whole list that I've made out, but I want this to help you. And so you guys email me, say, hey, here's a topic we would love to hear. And I'll definitely add that to the list. Okay, guys, have a good one. And you should get, I think it takes like, if this was an hour and a half webinar, I think it'll take about an hour and a half for this webinar software to process this. And then it'll just send you out a replay. It won't have these handouts, but if you didn't get them, just email me and I'll send them to you. So you guys have a fabulous weekend, and we'll catch you next week. Okay, bye-bye.